Your Honour, I appear today on behalf of the claimant and applicant, Mr. Liu. This is an application by Mr. Liu for an interim prohibitory injunction pursuant to Civil Procedure Rule 25.1. The application was made without notice. Your Honour, this was a result of the urgent nature of the application, which resonates from Mr. Liu's witness statement and which justifies the application being without notice. However, the Court should be aware that instructing solicitors have taken several steps to notify the defendant, Mr. Geddon, of this application and of today's hearing by contacting him by telephone and by serving the witness statement upon his last known address. Such notice has not been successful and the defendant is not present nor represented today. Your Honour, may I first check that you have received a copy of my skeleton argument, chronology and authorities? I'm grateful. Your Honour, there are a number of documents which I seek to rely on, and they have been listed for your convenience at paragraph 2 of my skeleton argument. Do you have those documents? I am grateful. The brief facts of the claim are that the defendant, Mr. McGeddon, was a previous employee of Mr. Liu, working at Liu Valley Spa in Abbots Lee. You'll see from the chronology that during his employment, Mr. McGeddon had suggested to Mr. Liu that he had been sleeping with Mr. Liu's wife, which resulted in Mr. Liu lashing out at Mr. McGeddon. Later on in his employment, Mr. McGeddon used severely aggressive language towards Mr. Liu and as a result was fired. Upon the verbal termination of his employment by Mr. Liu, Mr. McGeddon visibly presented as though he was going to attack Mr. Liu. As such, he was escorted out of the premises by security. Following his termination of employment, you'll see from the chronology, Your Honour, that there have been 6 incidents in which Mr. McGeddon has displayed or used harassing behaviour towards Mr. Liu, which have left him fearing for his own life, his family life, and his business interests. As a result of that harassment, Mr. Liu has suffered psychologically from distress and anxiety. Your Honour, you'll see from paragraph 8 in my skeleton argument, the application today is for an interim injunction pursuant to Civil Procedure Rules 25.1 to prohibit Mr. McGeddon from conducting harassing behaviour towards Mr. Liu, his family and his clients. A draft order has also been prepared, Your Honour, which details these specific prohibitions being asked for. Your Honour, you'll no doubt be aware that the general test for granting an interim application is whether it's just and convenient to do so under Civil Procedure Rules 25.1, and I would ask Your Honour to keep in mind what course of action would be just in this circumstance. Your Honour, as you'll see from paragraph 10 in my skeleton argument, the case of American Cyanamid and Ethicon is of utmost importance in this case concerning an interim injunction. It provides guidelines to follow, and as such, I will be addressing the Court on those considerations at paragraph 10 today. The first of which is whether there is a serious issue to be tried. This can be found from paragraph 11 in my skeleton argument. Your Honour, there is quite clearly a serious issue to be tried, as the defendant's actions are in breach of Section 1.1 of the Protection from Harassment Act 1997. As you can see from that Act, there is a prohibition on a course of conduct which amounts to harassment, where the defendant knew or ought to have known that the actions were harassing. If I could ask you to turn to the witness statement of Mr. Liu, it is paragraph 37 in that witness statement. In that, the third line down, halfway through the line, reads, "I am extremely anxious for our safety." Following on, Mr. McGeddon has subsequently been seen outside my family home whilst I was away on business, so this has caused me even more worry. As such, the effect of the defendant's actions has been to cause distress and or alarm to the claimant as required by the Act. Additionally, both the draft particulars of claim and the chronology which the Court has identifies a course of conduct per the Act, in that the events occur on more than 2 occasions, specifically 6 occasions in this case. Further, Your Honour, it is fairly clear that the defendant should have known that his actions were harassing, as he made verbal threats to both Mr. Liu's life and his son's life. There is no evidence to rebut this conclusion at this stage. However, I submit that it would be reasonable to infer that the defendant knew that this would be the effect of his behaviour, and as such, I submit that there is a serious issue to be tried. Your Honour, the next question is to consider whether damages would be adequate for the claimant should the injunction not be granted. You can see the reasons at paragraph 15 of my skeleton argument, where I submit to the court that the damages would not be adequate for the claimant, in that the losses to Mr. Liu are non-pecuniary, and you can see these at paragraph 15, in that they mainly consist of anxiety, worry and distress. Your Honour, there is a worry of interference to Mr. Liu's business at Valley Health Spa. If I could ask you to look back at the witness statement, paragraph 6, reads that while I was in Devon, I mentioned the problems to my staff and showed them a photo of Mageddon taken on my mobile phone. They said that they recognised him and thought they might have seen him a few days previously, speaking animatedly to members of the club outside the gates. I think that he was trying to interfere with my business interests. Mr. Liu is worried that such behaviour may have a negative effect on his business. However, should this result in any pecuniary loss, I'd submit to the court that damages would still remain inadequate because majority of the losses to Mr. Liu in this case are non-pecuniary. They are mainly around the anxiety, worry and fear for safety that Mr. Liu has suffered with. Your Honour, moving on now then to whether damages would be adequate for the defendant should the injunction be granted but later found that it should not have been. You'll see from paragraph 18 in my skeleton argument, Your Honour, that I submit that damages would be adequate, for the defendant should the injunction be granted but later found wrong. As you'll see from paragraph 18, Your Honour, Mr. Liu is willing to give a cross-undertaking as to damages. If I can ask you to look back to paragraph 2 of Mr. Liu's witness statement. My apologies. Paragraph 2 of that witness statement, the last sentence reads, "On a smaller scale, I own and run a health and safety consultancy business with my wife, which is known as Ray Kitten Limited and is based at my home." Your Honour, I have instructions that such an undertaking would be provided by that company with the express consent of both Mr. Liu and his wife. Your Honour, if I could ask you to turn to volume 2 of the White Book, it's page 2936. Yeah, there's guidance here in relation to cross undertakings at 1511. It is halfway down that first paragraph. It reads, "As far as the claimant," it's that first sentence, "as far as the claimant is concerned, the availability of him of such a remedy will normally preclude the grant to him of an interim injunction. If that is not so, as in this case, then the court should consider whether, if an injunction is granted against the defendant, there would be adequate remedy and damages available to him under the claimant's undertaking and damages. If so, as in this case, there will be no reason on this ground to refuse to grant the claimant an interim injunction." Further, Your Honour, as you can see from paragraphs 19 and 20 of my skeleton argument, the actual losses to the defendant should the injunction be granted are minimal. The effect would simply be to prohibit the defendant from harassing behaviour, which is already prohibited by law, by way of section 1 and 3 of the Protection from Harassment Act, as referenced previously. I'll move on now then, Your Honour, to look at the balance of convenience. And I submit in this case that the balance of convenience lies in favour of the claimant and the granting of the injunction. If I could ask you to look back to the white page, it's the next page over, page 2937. It's under the paragraph 1512. It's the second paragraph within that and the last sentence referring to the case of National Commercial Bank Jamaica Limited and Olent Corp Limited 2009. The last sentence reads that the basic principle in considering the balance of convenience is that the court should take whatever course seems likely to cause the least irremediable prejudice to one party or the other. As you will see from paragraph 22 of my skeleton argument, the fact that Mr. Liu is willing to make a cross undertaking as to damages is significant, as it immediately reduces any prejudice suffered or likely to be suffered by the defendant. Your Honour, you can see from paragraph 23 of my skeleton argument the prejudice which is likely to be suffered by Mr. Liu if the injunction is not granted. If I could ask you to turn back to Mr. Liu's witness statement to paragraph 37. It's the last sentence of that paragraph where he states, "I am worried that unless I have immediate protection, both myself and I," apologies, that is supposed to read my son and I expect, Your Honour, "are likely to be subjected to further threats and violence by Mageddon." Your Honour, if I could ask you to turn to the authority that I've provided you with of Potter and Price, it's paragraph 19 of that judgment. The court stated that where harm is capable of happening and there is a reasonably thought anticipatory nature of it happening, then an injunction would be appropriate. And I suggest that in this case, where such harm is anticipated and likely to happen, that an injunction would be appropriate, looking at the balance of convenience, in that it quite clearly indicates to the court that the claimant, Mr. Liu, is likely to suffer harm if an injunction is not granted. Further, Your Honour, the effect on the defendant is minimal should the injunction be granted. As I've previously submitted to the court, and as you can see from paragraph 24 in my skeleton argument, there are several factors to look at which relate to the paragraphs in the draft order. The first paragraph at 24.1 simply prohibits harassing behaviour, which Mr. Mageddon is prohibited from doing by law anyway, and as such, no prejudice to him in that. The second paragraph relates to prohibiting Mr. Mageddon from contacting Mr. Liu. If I could ask you to turn again to Mr. Liu's witness statement, paragraph 8 this time, Your Honour. It reads, "I made sure that we subsequently sent Mageddon his P45 and that he was fully paid for all the time he had spent working at the health club. As such, there is no material reason or reasonable reason why the defendant would need to contact Mr. Liu in the future, and as such there would be no prejudice to the defendants by imparting this prohibition in clause 2. The third paragraph of the order prevents the defendant from going within 100 metres of the claimant's home. Your Honour, if I could ask you to look back to the witness statement of Mr. Liu, this time paragraph 25. He states the third sentence down there, "My house is approximately a quarter of a mile from the Wetherspoons." Your Honour, a quarter of a mile equates to 402 metres. As such, this clause of the order would not prevent Mr. Liu's enjoyment of the Wetherspoons pub, which he frequently visits. As such, limited prejudice by this clause. Your Honour, there is a possibility that this clause would prevent the defendant from accessing part of Claresey High Street, which is within 100 metres of Mr. Liu's home. However, Your Honour, if I could ask you to look to the other authority I've provided you with, it's the case of Burris and Azadami. It's referenced at paragraph 24.3 in my skeleton argument, but is also referenced in the judgment at paragraph 18, which reads that such a restraint may be imposed if it is reasonably regarded as necessary for the protection of a plaintiff's legitimate interests. As such, I submit to the court that such a restriction in this case is necessary to protect Mr. Liu and his family, especially when the bench on Claresey High Street had previously been used by the defendant to watch the Liu's property. And as such, Your Honour, I submit that the balance of convenience lies in favour of the claimant in this case. And you'll also see reference to the status quo in my skeleton argument which within the time I will not refer to now. Unless I can be of any further assistance, Your Honour, those are my submissions.